Hello and thank you for being here. I'm Scott Listener and I'm going to present some information on your legal rights and protections in the workplace as a cancer survivor for the James Care for Life program. Topics today will include the Americans with Disability Act, the definition of disability and how it applies to cancer, the definition of discrimination under the Americans with Disability Act, a conversation about disclosing your disability, seeking a new position, reasonable accommodations and how to request them in the workplace, the Family Medical Leave Act, and then some resources. The Americans with Disabilities Act. Is the ADA civil rights legislation? What activities are covered by the ADA? And who is protected by the ADA? The Americans with Disabilities Act is a federal law that establishes a baseline for protections from discrimination on the basis of disability. Laws in some states provide additional protections from their local statutes. Congress acknowledged that society's accumulated myths and fears about disability and disease are as handicapping as the physical limitations that flow from the actual impairment. That's a quote from Justice Brennan in a Supreme Court case, Arline versus Nassau County in 1987, that really set the standard for how we look at discrimination under the ADA and related statutes. The ADA itself has several titles. The three that are most relevant to you as an individual who is a cancer survivor is going to be Title I, that covers employers with at least 15 full-time equivalent employees. Title II, which covers state and local government. And Title III, which covers places of public accommodations. Privately owned places that are open to the public, movie theaters, restaurants, bowling alleys, and places like that. The ADA's definition of disability is divided into three prongs, three categories. The first prong is a physical or mental impairment that substantially limits one or more major life activities of an individual. That's an actual disability, and we'll discuss it more in a few minutes. The second prong is a record or a history of such an impairment. That covers you if you have no ongoing symptoms, but have a history or a record that somebody is concerned about, and we'll discuss that further as well. The final prong is being regarded as having such an impairment, even if you've never had it, being thought of as a person with a disability. And again, we'll go into that in more detail. So the first definition, a physical or mental impairment that substantially limits a major life activity, raises two questions. What is a major life activity and when is it substantially limited? So a major life activity might include seeing, hearing, eating, walking, sleeping, breathing, thinking, the operation of major bodily systems and functions such as the immune system, the endocrine system, the digestive system, and normal cell growth. It's not an exhaustive definition. It's an includes but not limited to list. And normal cell growth was included when they amended the ADA specifically to ensure that cancer was covered as a disability. The purpose of Prong 2 is to protect you if you have a history of an impairment. You may have no active symptoms, you may be in remission, but someone who is aware that you've had cancer, aware that you've been in chemotherapy, may treat you differently. And this prong is intended to protect you if people treat you differently based on the knowledge that you had cancer, and that differential treatment excludes you or reduces your opportunities or your benefits in the workplace. The purpose of the last definition is when you've actually never had the condition, but people assume for some reason that you have a disability. The classic example in the original legislation was you have a scar or a disfigurement of some sort, and people assume that it limits you in ways that it does not. So there's no substantial limitation. There's no major life activity. There is simply a disfigurement of some sort. and people make assumptions about it. In the context of cancer, that might be because you were seen to be supporting a fundraising event for a cancer program. It may be because you had a mammogram, there was a problem with the image, you got invited back to go for another mammogram, you let work know you were leaving early 2 different days in the same week for a mammogram, and they make assumptions that you must have cancer and that it's problematic. If there are assumptions about your having a disability, if you have a record of a disability, but don't actually have any impacts, you would not be entitled to reasonable accommodations, but you would be entitled to not be discriminated against, not be excluded based on those assumptions. Discrimination. Cancer is protected by the ADA. Discrimination based on cancer is illegal. Employers with 15 full-time equivalent employees, government agencies, government services, including education, and private businesses offering goods and services to the public are all covered by the ADA and can't discriminate against you and must provide reasonable accommodations. Discrimination comes in a variety of forms. We'll talk about some examples that are exclusion, some that are based on association with an individual who has a disability, based on accommodations, and based on retaliation having disclosed your disability, on how you are treated. Forms of discrimination include limiting, segregating, or classifying a job applicant or employee in a way that adversely affects the individual's opportunities. So that's that exclusion. Participating in a contractual arrangement that has the effect of discriminating. So if your company hires out custodial services and that custodial service discriminates, that's your company discriminating. You can't discriminate by contract. Using standards or criteria that have the effect of discriminating. So when you set workplace standards for hire, when you set standards for continuing employment that are based on disability and health rather than based on business necessity and job duties, that would be discrimination. Associational discrimination is when a spouse or a child or a family member has a disability, or when you participate in an event that's around something with a disability, like a walk or a fundraising event of some sort, and people treat you differently based on your association with individuals who have disabilities. Not making reasonable accommodations when requested, using qualification standards that screen out people. I kind of mentioned that once already in using standards. And failing to administer tests on a non-discriminatory basis. So if you have a certification test or a credentialing test in the workplace and it's not administered fairly and with appropriate accommodations as needed, then that would be discriminatory as well. Associational discrimination is really treating someone differently because of a known disability of an individual with whom that employee is known to have a relationship. So if my wife has cancer, if my wife has a disability, and they're concerned about promoting me because I might need to take time off for my wife's care, that would be discrimination by association. Not making reasonable accommodations. You have to be qualified to perform your job, but you can perform your job with reasonable accommodations. Modification or tools, modifications to the process, to the schedule, to those kinds of things. Adaptive computer software to help if your vision has been impacted, if your ability to deal with contrast has been impacted, if your mobility with the mouse has been impacted. Those would all be reasonable accommodations. You can seek accommodations that would facilitate performing your job. It has to be connected to your job. And in the process of being accommodated, you still have to do the essential elements of your job. You can't waive or accommodate away the purpose of your job. So if I'm a warehouse employee and my job is shelving and pulling off the shelf, I might get a tool that is a lift on a motor that I can roll up to the shelf, raise up to the right level, pull off the item without having to bend or lift too much, move it on to where it needs to go. That would be a reasonable accommodation. But I can't, as a warehouse shelver, say, as an accommodation, what I need is to never lift anything. I might need to look at another job within the company, and there are some protections there, but it would not be reasonable for the accommodation within that job as a shelver, so to speak. Retaliation is a negative action in response to letting someone know you had a disability. If it has an adverse employment action, there may be a direct discrimination complaint. So if it limits your ability to get a raise, to get a promotion, if you get demoted or transferred to a less productive, less compensating position, if you're bullied or teased about your disability and you let your supervisor know, you let your company know if it's your supervisor and they don't respond to controlling that behavior, those are all things that would qualify as discrimination through the retaliation section of the ADA. Disclosure, decisions, and confidentiality. When do you need to disclose? What information should you disclose? What happens when your condition is found out accidentally? And confidentiality and the need to know who in the workplace really needs to know what. When to disclose? When you need to request an accommodation, your employee is entitled to know you have a disability with certain impacts that require accommodation or that could use accommodation. So you have to disclose that you have a disability, depending on how your doctor and you discuss it and wish to frame it. That just has to say you have a disability. It doesn't have to identify the specific. And it does need to identify the impacts you want to be accommodated, whether it's fatigue or it's a back issue that requires a sit-stand workstation, fatigue that might require breaks. The documentation would need, your disclosure would need to say, I have a disability, it impacts my energy level, I need a break once every 3 hours. It impacts my ability to sit or stand for extended periods of time, so I need a sit-stand workstation. That's the kind of information that has to be there. If your disability is apparent, and people assume, perhaps accurately, that you have a disability at that point, your employer is not obligated to assume what accommodations you would need and make some guesses. They might proactively share with you, we have a process, here's who to talk to, do you need anything? But other than that, they are largely supposed to ignore that apparent disability, that accidental disclosure. That might also happen if you participate in a fundraiser that gets posted to Facebook or other social media where people assume, because of that connection, that you have a disability. As I said, you need a general statement that you have a disability, and you need to describe the impacts of that statement, but you don't have to provide all of the details of your medical condition. You don't even have to provide diagnostic information. You have to provide kind of functional impact information. So you have a disability, it impacts and limits a major life activity of some sort, and here are the impacts that are relevant to the workplace. Once you disclose, if it's accidental, as I said, your employer's obligation is not to act on that in inappropriate ways. They're not obligated to make assumptions about what you might need. You would still need to make a request there. Accidental disclosure, apparent disability, and reasonable accommodations all can be seen and observed at some level by everybody that works for you. So if you have that sit-stand workstation, if you get breaks because of fatigue, and those are not in place for everybody, some of your colleagues will ask you, Why do you get to take a break? Or they may complain to the boss. Joe gets to take a break. Why can't I take a break? Why don't I get a sit-stand workstation? So you need to think through on a social level how you're going to share that with your colleagues in the workplace. The employer, in good practice, would only say something along the lines of, I work with every individual in the workplace based on their needs. If you have needs, I'm happy to talk about your needs, but I'm not going to discuss another employee's needs with you any more than I will discuss your needs with another employee. So it'd be your decision of how much personal information to share amongst your colleagues in the workplace. But if they can see things, they're going to be curious about them. And when you don't satisfy their curiosity at some level, that can be uncomfortable in the workplace. Sometimes emergency medical personnel may need to know a little more information depending on the nature of your workplace. So at OSU, we're big. We have our own first responders. We may share some additional information with their dispatch unit so that if there's an emergency where you work, they're prepared to handle your particular needs if it relates to how to evacuate or what to do in the case of an emergency. Typically, your supervisor, a manager, a shop steward, someone is going to need to know that you're being accommodated to implement those accommodations. But they only need to know that an accommodation has been approved, this is how it should work. They don't need to know much information about your actual condition. Medical information should be kept in a separate file from your general personnel folder, not made general information around the workplace, not shared with other employees by the supervisor who's implementing the accommodations, beyond that basic statement about things that are noticeable, unless you've given them guidance on what it is you think is appropriate for them to share. Reasonable accommodations and how to request them. What is an accommodation? How to request an accommodation? When is an accommodation reasonable? And when is the answer no to an accommodation request? An accommodation is a modification to policy or practice or the environment, the provision of a tool or a service that reduces the impact of a disability and allows the individual an opportunity to perform their job duties or to participate in programs and services. We're going to focus on performing your job duties in the workplace, but accommodations are available in education, in retail establishments, in hotels, in a variety of those contexts that are open to the public, or in government services and programs. You as an employee must trigger the accommodation process by making a request. There's no magic words you have to use, but being clear is always a good idea. So you need to make a statement that says more than "my back hurts" by the end of the day. That's a little hard to read as an accommodation request. I have a medical condition, I have an ongoing back condition, and I have difficulty with the workstation here on a regular basis. Hopefully your employer would hear as an accommodation request. But even better would be going to the right individual. It may be your supervisor, it may be somebody in human resources, and saying, I have a health condition, it affects my back, and I'm having difficulty by the end of the day sitting at my workstation, or doing the amount of walking I have to do on the job without a break, or seeing what's on my computer screen. Connecting health condition to impact that needs accommodating. And certainly if you have ideas of what would solve the problem, you're not expected to be the absolute technical expert, but as the individual, you may have a lot of good ideas for what would make it work. You may have a chair at home that is comfortable for longer periods of time, and you could say, I need a chair, something like this, as part of that accommodation request. That should trigger a discussion, not simply a, here's what I need, provide it, end of conversation, nor should it be a simple no from the employer, that's not something we can provide, that doesn't work for us. No, it should be an interactive conversation. If what you're requesting is unclear, they should ask for more information from you, some clarity, maybe some documentation from your doctor. If there is a reason for them to say no to your first request, they find it problematic, they should be asking, are there other ways we can accommodate you? Or potentially making suggestions about other ways to accommodate you. So an accommodation must be reasonable. It must be workable and allow you to get the job done, but it doesn't have to be the best accommodation that might be asked for. So if there are two ways to accommodate you, and one is the gold standard high-end piece of software on the computer that is artificial intelligence and pretty much does everything I ask it to, versus a piece of software that's a little less intelligent but gives me the screen enlargement and the control over the mouse that I need to effectively do my job, they can buy the cheaper software that gets the job done and don't have to buy the gold standard piece of software for me. Reasonable accommodations really are anchored to what your work is. And so they can take a variety of forms, and this list is not exhaustive, but it's an example of typical accommodations that might take place in the workplace. So it might be about modifying the environment, putting in a ramp, putting in a little more maneuvering clearance for a wheelchair, reorienting a workstation so that you're not facing a brightly lit window during the day if bright lights are a problem. A variety of those kinds of things that are about the physical environment. It might be restructuring your job duties, rearranging how they're organized, occasionally carving out a piece of the job you do and a comparable different piece of a job that some of your colleagues do, and doing some job restructuring between two jobs. So if once a month I have to travel for a day, and that's not a really central part of my job, but it's something I've always done, we might make arrangements for somebody else to take that extra day of driving if I have 4 or 5 other people doing the same kind of work as me. And I would pick up some paperwork or some telephone work or some other work that would compensate them for spending a day out on the road, that would reassign those duties. If everybody in the office takes turn once a week sitting at the reception desk during lunch and answering the phone because the receptionist who does that normally needs to eat lunch, and I have a very strict schedule for eating that interferes with that, we might modify the timing, or perhaps somebody does 2 stints at the reception desk and I pick up some paperwork or some other work to compensate for that hour that the other person is now doing out of my job duties. So those kinds of things are possible. Modified work schedules are possible. Remember, the goal is to keep getting the work done. And so it is, in a lot of contexts, difficult to say, I need a permanent job that's part-time. But there are positions with a large enough workforce doing similar work where that's possible. But if you work part-time, you get paid part-time. Modifying your schedule, an earlier start time, a break in the middle of the day with some extra hours at the front of the day or the end of the day or both, are all things that are quite possible in many jobs. If you work an assembly line, that might be difficult. But in most desk jobs, in most jobs, that's a fairly doable kind of accommodation. If there is no way to accommodate you within the job, you worked on that assembly line and you needed those breaks that I couldn't provide there, I might look at, was there another position that was open that you had the skills for, that was comparable in terms of pay and shift and things like that, that I could reassign you to so that you could be accommodated. I've already talked about adaptive equipment. If there are examinations for promotion, for maintaining certification in a job, if there are those kinds of evaluations, appropriate accommodations on those. If I need, because of some cognitive impact, a little extended time or a large print version, or a version that allows me to do typing instead of handwriting to respond, those would all be reasonable accommodations on kind of workplace certification exams, training exams. Similar accommodations on training materials, provisions of somebody to read or voice output software, an ASL interpreter is a reasonable accommodation in most contexts if you had a hearing impairment. And you can, in some instances, request modifications, extensions of leave that might interact with the Family Medical Leave Act. And we'll talk about the Family Medical Leave Act in another section of this presentation. The accommodation is not always reasonable. So when the answer is no, when you've gone through that interactive process with your employer, they might point to an undue burden. It might be about the cost of the accommodation. That would have to be substantial. It would have to be compared to the overall budget of the employer, not just the one division you work in, not just the one office you work in. But if there are substantial costs that would impact the ability of the employer to continue to do business effectively, that may be an undue hardship. That standard is much higher for government employers than it is for private employers, as a rule. And it's higher for larger employers than it is for smaller employers. So there's no value set on that cost. It is an analysis of the situation and the context. More likely than cost being a reason to say no is it impacts your ability to do business as an employer. It disrupts the business flow. It significantly impacts productivity. It significantly impacts getting the essential parts of the job done. That would be another type of hardship that would be a legitimate answer to no. And as we've said a number of times, if the request you asked for, let's say for the sake of argument, was 3 months of additional unpaid leave as an accommodation beyond any other leave you might be entitled to under family medical leave or earned leave policies or medical leave policies or vacation policies, the employer might say, we can't make that work in terms of its impact on our workflow, but is there something else that would help? Could you do 50% of your job as telework from home? And would that allow us to be able to accommodate you and extend partial leave for another 3 months? And would that allow you to be able to work effectively? So that kind of conversation would need to take place. So that's exploring alternative accommodations. We've already mentioned in the last slide, reassignment to a vacant position where you could get the job done and get accommodated at the same time. You might explore family medical leave as an alternative to accommodations. If you are at an employer large enough, 50 employees, to be covered by family medical leave, and you've worked there long enough to have coverage. And again, there is another resource on family medical leave later in the program. And it may mean that you start a job search for another position in another company that would allow you to get the job done and meet your needs in terms of accommodations, or just simply a job that doesn't interact with your disability, your impact, the same way. Seeking a new position. What can an employer ask in the application and interview process, and what happens, what can the employer ask after they've made you an offer? While you're applying for a job, your employer can't ask you, do you have a disability? Directly. They can't ask that by asking you questions that serve as proxies for asking if you have a disability. So they can't ask a lot of health information in an application process. They can't ask for a driver's license if a driver's license isn't an essential element of getting the job done, isn't a job requirement. So if you're a manager, they can't ask you if you have a driver's license. If your job is on one site and doesn't require driving around the city to supervise people at various sites. You can, of course, as an applicant, voluntarily disclose your disability, but like I said, the employer should not ask you that question. If you choose to voluntarily disclose, you might do that because some of your disability is apparent and obvious, and you want to get it on the table to make everybody comfortable because they can't ask and they may wonder. It may be because you need an accommodation in the interview process. You know that you will have difficulty reading material and filling out forms, and it's clear from the call for an interview you would need to do a test of some sort on the site, and you might ask for accommodations for that test. The employer's response should be limited to the accommodations that you've asked for in that process. But once they make an offer, they might say, for this job, say a job at the medical center here at Ohio State, where we need to know you don't have any contagious diseases and that you've had the appropriate vaccinations and shots to protect you as an employee and to protect us as your employer. We can make some medical inquiries or ask for a job-related physical exam as long as it's work-related. The results of those exams cannot be used to discriminate, to limit your opportunities unless they are directly related to your work. So if we discover you need a vaccination, we can delay your start date as a reasonable accommodation. But as long as you're willing to get the vaccination, we couldn't say, because we've discovered this, we're withdrawing our offer. So we can use those evaluations that are necessary to business to discuss how we might accommodate you, but we can't use them simply to say no once you've been hired. We have a number of applicants to our medical center that disclose latex allergies. Turns out we use almost no latex any longer in the medical center, and that's fairly easy to accommodate, but we might take a moment when you get that required, when you respond to that required form to identify your work-related health issues. If you disclose that latex allergy, we take a moment to ask to make sure we understand what you've disclosed and that we're not putting you at risk without making reasonable accommodations. The Family Medical Leave Act is separate from the ADA, but at times overlaps with it. It is an entitlement granted by Congress, and we will talk about what employers are covered, what employees are covered, what types of leave are available, whether or not it can be paid leave, how much leave is available, other rights you may have under the Family Medical Leave Act, and how you can be required to identify and give notice, and notice required from your employer. So to be eligible as an employee, you must have worked for at least 12 months for that employer with at least 1,250 hours of work in that 12-month period. So at first hire, you won't be eligible for family medical leave until you've put in a year and put in at least 1,250 hours of work time. Once you've done that, you're eligible, and your continued eligibility is having worked 1,250 hours in the previous or the most recent 12-month period. Your employer can choose to use a calendar year from January to January, or a rolling year based on your start date, or based on your first leave eligibility and request date. An eligible employee, once you're eligible, you are entitled to up to 12 work weeks, 12 weeks of leave during a 12-month period of time. There are a variety of reasons that would support that leave, that would make you eligible for that leave. It could be the birth of a child or the care of a newborn that overlaps with your maternity leave if your company has one. It could be adoption or getting a foster child and needing some leave to get that organized. It could be to care for your spouse, your son, your daughter, a parent who has a serious health condition, and we'll talk in a few minutes about what that is. It could be because of your own serious health condition that makes you unable to perform some aspect of your job. Employers who have 50 or more employees are covered by Family Medical Leave Act. And state and local government employers are covered by the Family Medical Act, regardless of how many employees they are. Congress decided 50 employees, unlike the 15 that are required under the ADA, because family medical leave is an entitlement. It is 3 months of holding a position open for an individual, and it has a fairly significant economic impact. And so they chose 50 as companies that size could afford to cover the entitlement that the Act provides to the individual employees. So if you have a serious health condition, that very much overlaps with the ADA's definition of disability. An injury, an impairment, physical or mental health condition that involves inpatient care or ongoing treatment from a healthcare provider is the phrasing used in the Family Medical Leave Act, rather than a substantial limitation to a major life activity, which is the phrase used in the Americans with Disabilities Act. But they equate to very similar coverage for very similar conditions. The difference is the ADA provides less coverage. It does not require leave for a family member who has a disability, for caring for a family member who has a disability, in the way the Family Medical Leave Act does. Employers may make limited inquiries about your status to make sure you are eligible for FML. There are standardized FML certification forms, and employers can ask for clarity, some additional information on those forms at times. Making those inquiries is not violating the ADA's mandate against asking questions about disability. Clearly, you're already an employee. You initiate the family medical leave process, and so at that point, it's not an inquiry into disability. An employee's own health condition. If you have a serious health condition and are unable to perform one or more of your essential job functions, you would be eligible for family medical leave. If, on the other hand, you have a serious health condition but can perform all of the functions of your job, all of the essential functions of your job, then you are not eligible for family medical leave, though you may be eligible for an accommodation under the ADA. If, as an employee, there's some aspect of your job, some essential function you cannot perform, but you do not have a serious health condition, you are not entitled to family medical leave. If a family member is unable to care for themselves, if they have a regular set of appointments, if they need some personal care, if they need some assistance with feeding, some intermittent leave or some leave for a period of time while they're in recuperation would be a reasonable leave under the Family Medical Leave Act. That might include someone with a psychological disorder, a mental health condition, someone who gets panic attacks based on a condition and needs some ongoing care or some intermittent care. It would also include the occasional need to substitute because you have an aide that comes in and does care and calls off sick, and that might be a Family Medical Leave Act covered absence to call out the last minute because you got a call in from your aide or attendant saying they couldn't come in to take care of your spouse. So while you're out on leave, your health insurance is maintained. If you have a portion of the insurance that you pay out of wages, you still are obligated to cover your half of the health insurance. But your benefits stay in place while you are covered on family medical leave. If you've been out on continuous leave for 12 weeks and you come back, the employer is obligated to place you in the same or an equivalent job on your return. So if for business necessity they had to fill your slot on the assembly line, couldn't leave it empty for 3 months, would bring things to a halt. When you come back, a job on a similar shift for the same rate of pay, et cetera, would be available to you under the Family Medical Leave Act. It does cover intermittent leave. I've mentioned that a few times in discussing leave. So intermittent leave would be occasional. It would be triggered by some event. It might be that attendant that was late that's taking care of your child with a disability or a spouse with a condition who's in recovery. It might be because I have chemotherapy and I'm on a cycle that most of you will recognize. I'm working, I go in for chemo, I need a week off of continuous leave, I come back from chemo, and I need some intermittent leave of only working 5 half days or only working 3 days that first week back because of endurance issues coming back from chemo. Over the course of a few weeks, I progress back up to working full time. And then 2 months down the road, I'm going to need another intermittent leave pattern similar to that because I have another round of chemo. That would be intermittent leave. A flare-up that was unanticipated, a reaction to medication or treatment, those are other things that might require some intermittent leave. When it's foreseeable, it's easier to contend with, and an employer may choose to put you in another position where it's easier to contend with intermittent absences if we know you're going to have 3 to 5 absences over the next any given month, but we don't know exactly when they're going to be. So if you're in a direct customer interaction job, absences may be harder to deal with, and we might move you to a slightly different job as long as it didn't put you in a negative status, as long as it wasn't retaliatory in the sense of you were paid less, or losing opportunities for commission. But if you were on a non-commission sales force and they put you on the phone rather than out front because those absences were harder to cover when you were out in the field doing demos and had to cancel and reschedule, that would be reasonable under the Family Medical Leave Act. FML leave will interact with your earned leave if you have an earned medical leave program at your employer. So if you get 4 weeks of earned medical leave because you've been at work long enough and earned that benefit as an employee, and you take family medical leave for 12 weeks, the first 4 weeks does double duty, unfortunately, or it can do double duty if the employer wants it to do double duty. So you could be paid the first 4 weeks because you have 4 weeks of paid earned leave, and you could drop your balance of paid earned leave down to 0 the first 4 weeks. For the next 8 weeks, because you have another 8 weeks of family medical leave, you are protected out on leave. They have to hold your job for you. They have to keep your benefit package going. But you are not paid. The family medical leave does not require paid leave. And so for the next 8 weeks, it might be unpaid leave. So your employer can set it up to do that double duty if the employer chooses to. And many employees want that because they want the pay the first 4 weeks at work. But that may be a careful decision about what the length of my leave might ultimately look like and whether or not that's to my benefit. But the employer can set it up that way. If you have a choice, your employer can make it a choice. And your employer is obligated to give you some notice about how they're set up, what your eligibility are, when you're running out of leave, et cetera. To give your employer notice that you are going out on family medical leave, you need to tell them more than I'm sick and I need leave. You need to provide them enough information, and they'll have a form in all likelihood that describes that it's a serious medical condition and that you're under a provider's care. When you call off sick, you might be sick with a cold. You might have overdone it on the weekend and strained your back. It might have nothing to do with your cancer or your disability. In which case, when you call in sick and you have family and medical leave eligibility and other kinds of leave you might take, you need to alert your employer that I'm taking family medical leave. You don't necessarily need to tell your immediate supervisor, I'm taking leave for my cancer treatment, I'm taking leave for my depression related to my cancer. You just tell them I'm taking my family medical leave. Many employers, particularly large employers, will separate out the leave forms with all of more personal information on it from your supervisor who is processing your day-to-day, I've called off sick, right? So you can give that information without necessarily revealing all of your condition to your immediate supervisor. Once the 12 weeks are up, if you've used up all your available leave under Family Medical Leave Act, you should get notice that you're about to use up your leave. You can, under the ADA, request an extension of unpaid leave as an accommodation to your disability. When you do that under the ADA, that extension of leave must be bounded. You must be able to, with reasonable reliability, say, here's when I will be back, in a week, in a month, in 3 months, whatever it is, but a reliable return to work date. How much time is going to be an undue burden, how much extension of leave would be problematic for your employer is going to depend on the size of the workforce and the nature of the work. If I have 80 employees who all do similar work and lots of them like overtime because they would like to earn some extra money, granting you an extra few weeks of leave is not going to be an undue hardship. But if I have 3 employees and you've already been out for 12 weeks and you're asking for another month of unpaid leave as an accommodation under the ADA, that may be significantly impacting the other 3 employees whom I've told you can't take vacation, you can't schedule appointments during the workday, I need you to pick up a third of this other person's work while they're out on leave. At some point, that may be burdensome on the employer and the other employees, and they would say no under the ADA. But while you're covered by the Family Medical Act, there is no for any of those kinds of reasons. That's an entitlement. So if you were out on 12 weeks of leave from a sales position, and you did that so that you could receive radiation treatment, and then you request an additional 3 months of leave. If the employer terminated him 8 days later, so that's a hypothetical, that's a set of facts, out on FML, covered and documented, I see the end of my FML and I need another 3 months of leave to be ready to come back to work. I'm a salesperson for this company, and the employer says no. The questions that you might ask if it was a trial, the questions you might ask if it was a complaint with the Equal Employment Opportunity Commission would be, was there a conversation? Was there an interactive, good faith effort to find an accommodation that would meet the needs? If the only thing that would meet your needs were leave, was there additional leave? Was there at least a conversation about could any of this work be done using Skype or FaceTime or the telephone? Were there other accommodations that would allow you to do the critical parts of your job that would not otherwise be getting done? If you can't work, then at some level you're not qualified for work. The question would be, what's the impact of that additional 3 months? And was that a substantial impact on the employer? Was it an undue hardship? Was it truly impacting long-term productivity in business? Or was it simply paying a little extra overtime because other people worked overtime and were happy to do so? So in my previous example, I talked about people who want overtime versus mandating overtime to individuals would be a very different business setup. And if I have to mandate overtime, if I have to say no to vacation requests that people are otherwise entitled for, that additional leave, to make that additional leave for you work, then that might be a reason to say no. So if you cannot return to work, and you cannot identify a reasonable time frame or accommodation that would allow you to work, at the end of that family medical leave process, after you engaged in a reasonable accommodation process, you may be at a point where ending that position, whether you do so voluntarily or whether your employer terminates you, is the only viable option at that stage of the game. I have identified a few resources that I think would be helpful in following up on this conversation. The Job Accommodation Network is generally a very good resource. They have a resource that's linked here on accommodation ideas for cancer that you might review before having a conversation with your employer to help identify ways in which you might be accommodated that would make sense to help you generate more ideas. The Equal Employment Opportunity Commission, the federal agency charged with enforcing the Americans with Disabilities Act, has a number of useful documents, including one focused on questions and answers about cancer in the workplace that looks at both employer rights and responsibilities and employee rights and responsibilities. When cancer leads to workplace discrimination, that is more focused on the employee and a little less focused on the employer, and can help you fully understand your rights under the ADA. And the Department of Labor, which is responsible for enforcing the Family Medical Leave Act, has a number of documents available at their website describing your FML rights and responsibilities and your employer's rights and responsibilities. Thank you.